for those of you who don't know this, maybe it's a good idea to go through a little bit of history. So this started in basically so in 2004 or something like that. We started working on what became this staff discussion paper on exclusionary abuses. I should say what I call it landmarks. It's only the policy landmarks. I mean, there are cases, very important cases that I will not talk about. Anna Pisakevich will do that in the next. I got it right. We'll do that in the next lecture. So there are some cases from the Commission. There are some court cases, very important one, including the Google judgment that just came out last month. I'll not really talk about that except mentioning it in sort of a little bit in the sideline. So I'm really talking about. I will talk about the policy paper and what it seems like the Commission wants to do now. And my view of that. So let's take a look at these, what I call the landmarks. So the first one is what's called staff discussion paper on exclusionary abuses. As I said, I was a member of that team. It was a result of many discussions, or maybe we should call them battles internally. The policy directorate at the time and the top management of DG Comp and also the commissioner at the time wanted to do something about Article 102, have some more economic analysis, less automatic condemnations of certain practices. And as I remember it, the area where a lot of people at the time thought the Commission had really gone too far was rebates, especially what's called a Michelin 2 rebate. And I apologize to our Philippine friends that this may be a bit, this will be very Europe-centered, unfortunately, for you perhaps, but I hope it'll be interesting still. So Michelin 2, where there was an analysis of it's called retroactive rebates, which were basically given on the basis of quantities, which seemed to a lot of people that we have really gone to, the Commission had really gone too far. So that was sort of the one thing we really had to come up with something with. And it was perhaps not the best solution in the end we came with, and it's probably still the most difficult area 20 years later. That sort of very shrewd observers of how things work in the Commission would already from the title see that this was not really the normal way to do things, because it was called a staff discussion paper. So it was a staff paper, so it's not like a formal paper of the Commission. It was a discussion paper. It was not draft guidelines as we have now 20 years later. So there was already something saying there was something going on underneath the carpet, that there were some debates going on. And then also something, if you see the next thing was that normally when you do something like the draft guidelines that come out now, you would expect the final guidelines to come out in a year's time. There will be some consultation and then they will come out. It took 3 years before something which has never existed before, which was a guidance paper, came out. So that was a long time. There was a lot of discussion going on. I got fed up and left also because I got a chance to go to the chief economist team where I wanted to go sooner or later, but also I didn't really know what was going on, why we were stuck for these for years. So I left in 2007. So then in 2008, my ex-colleagues there came out with this, it has a very strange title. So the full time was Communication from the Commission, Guidance on the Commission's Enforcement Priorities in Implying Article 82 of the EC Treaty to exclude abusive exclusionary conduct by dominant undertaking. So 82 was the old, now it's 102, but it's the same article, right? So it was a guidance paper on enforcement priorities. It was not guidelines, it was not even draft guidelines, although it looked very much like guidelines, right? So it was clear, everybody knew that my colleagues and also me in the beginning, we thought we were working to produce guidelines. We were just not allowed to do so in the end. So, and there was still a strange document and a strange title, and people have criticized this for many years because this thing about enforcement priorities, it sounds like a document where the Commission would tell you, well, we want to maybe work in specific sectors or prioritize certain types of behavior, but that was not what it is. The priority was that we will do where we think there's most consumer harm. And I mean, normally that's what you do anyway, right? So it was a bit odd, right? The whole thing was a bit odd, and the paper was there, and in the end, the parts of the commission didn't really want to rely on it. The legal service never really liked it very much. So it was this odd thing that was hanging there, but at the same time, the courts had read it, and it sort of sneaked this way into certain judgments. And that was there for these 15 years, having a very strange position. Not really, people didn't really know to what extent the commission would rely on it or not, whether the commission felt it was bound by it or not. And then now we are moving ahead. So in March last year, there was a communication with an annex, and then also at the same time a policy brief published. And basically what it did was to say, well, there's this guidance paper there, but there actually been some judgments from the courts, which means that some of the parts of the guidance paper are basically wrong, do not reflect the case law, which is true, right? And so it came out and said, this is what we think the changes should be to the guidance paper as it is. So this paragraph should be different, so and so. But at the same time, it also said that, well, we will move towards guidelines. We'll start the process of making guidelines. In the policy brief, it said that these guidelines should be what we call a workable effects-based approach to Article 102. And we'll come back to this workable business. Then on 1st of August this year, the Commission then published draft guidelines. And the process should normally be that next year we'll have guidelines, unless they run into trouble again. And they are, there is a bit of fire going on from the comments that already in these couple of months have been out. There are a lot of people saying, criticizing it. So we'll see what happens. So what I will do in this lecture now is try to give you an idea about what the Commission is signaling with these draft guidelines. Where would it like the enforcement of Article 102 to go? I will focus on what I think are the most interesting changes and therefore sort of hints of the future. It will be a slightly eclectic lecture in that I will not go systematically through every page and comment on it. I think I will mention most of the things, but I will focus on certain things. So, and then I will criticize it. So it's a bit of a strange animal. I will sort of say what is there, but not sort of as sort of a lecture saying, now you have to learn this and come back in an hour and pass an exam. I will sort of give an overview of that. And then I will say, where do I think the problems are, if there are problems? And where is it fairly obvious what they have done, right? And I see also that, I mean, you seem to have had the chance to be experienced. So I will not. I will imagine that all of you at least know what Article 102 or abusive dominance or the unilateral behavior is. How many of you have actually worked on 102 cases or? Okay. Good. So you will recognize something, I hope. So, and since I'm an economist, I will some of the comments will reflect, of course, that I am an economist, and I should come clear in saying I'm skeptical about some of the things they are trying to do compared to the guidance paper. Maybe it's just because I was involved in my guidance paper, so it's a little bit my baby, and maybe I'm just getting old and don't like changes. But I'm not sure it's the only reason. And there are other people, as I said before, experienced people who have raised a good deal of skepticism. And I'll give a couple of references towards the end if you're interested in reading some of the things that have come out or are coming out shortly. I should say also that I have a good deal of sympathy for the task that my ex-colleague had to do. I think the case law is not exactly an example of clarity and consistency. It's probably also moving in some ways. So summing it up is a bit of a challenge. On the other hand, what that also means is what you do when you do something like this, you pick and choose, right? Because there can be various narratives. You can construct various narratives depending on where you think you would like to go with this. So even if it's true that you are reflecting the case law, which is what they are saying now, guidelines reflect the case law, right? So we have to, and you'll see comparing the guidelines to the guidance paper, there are many more references to judgments than there was in the guidance paper. Economists like me, right, try to think about, well, how do we think it should be, and it should be consistent, and then we sort of try to write that, and then we say, okay, can we find a couple of references that fits that? I mean, lawyers, I think, feel very much they have to have sort of be able to say, this is here, this is here, this is here. But the thing is, you can have a line over here, a narrative over here, where you can find references for everything you're saying, and you can have another line which is very different, and you can find references for everything from that, right? So you do make choices when you do this, and they have made their choices. So let's go to what the commission to the draft guidelines. So this is from a presentation that the person who is leading the team who's doing it made here in Florence, actually in September, and I asked him for it and stole it. His name is Maximiliano or Max Cada, Italian, a very bright guy, and this is what he said are the objectives, and the first two are fairly obvious. The third thing has this thing about the workable effects-based approach, which is firmly grounded in economic thinking and conducive to a robust and effective enforcement of Article 102. And of course, I think the subtle message is saying here in that last thing is, well, we are not going back to a per se. No. It is grounded economics. It's just a slightly different type of economics, right? And so that we can have a robust enforcement. It is workable, which sort of sound like, well, what was there before was not workable, right? If you now are doing something which is workable, right? So the message here, if you read it, is, and I think that's also the way they do it, Commission wants easier, faster enforcement while still grounded in economics, according to them. So it's not per se, but they want it to be faster. And maybe probably also quicker. And we'll see how they do this. So let's first see a thing in the introduction. Now, in the introduction in one of these documents there's often a lot of blah, blah, all about the objectives of the competition law and how it fits with other parts of what the Commission does. And this is where, because these kind of documents are negotiated with all the other parts of the Commission. It's not only Comp that does it, right? So it has to negotiate with the other parts of the Commission. And the other parts of the Commission think what they're doing are very important. So they want some words in there that reflect that. They would like some words all over the place, but what Comp then does typically is put words like resilience and sustainability in the introduction. Then it's there, and then often you have to look very hard to find trace of it later on, right? So, but what I look for is a bit what do they say the objectives are, right? And here they're saying Article 102 applies to all practices by dominant undertakings which may directly or indirectly harm the welfare of consumers, including practices that may harm consumers by undermining an effective structure of competition, particularly by hindering through recourse to means or resources different from those governed normal competition, the maintenance of the blah, blah, blah. So it's consumer harm that makes me happy. It's a competition objective. There's nothing about industrial policy. There's nothing about sustainability and resilience or whatever other words which could take us away from a competition-focused enforcement, which I think is a good thing personally. I'm not sure this I say here. You see, sometimes I have something in red. I'm not sure I'm completely consistent that all my comments are in red. So but sometimes in red I've thrown in what I've thrown as a comment. And this is actually from the case law. I'm still not really sure by recourse to means or resources different. What that really means? But it was more as much a thought to myself, or you can think about it when you go home, right? So I'm reasonably comforted by this. It's a competition-based criterion. However, I'm not really sure that what you see here is reflected later on directly in the way in the test and so on that the guidance paper or the guidance draft guidelines propose. So that's a little bit one of my worries. Okay, then quickly it has deals both compared to the guidance paper that only deals with single dominance. The draft guidelines deal both with single and collective dominance. And collective dominance, so somehow an abuse of a dominant position held by more firms. How do we find this dominant position? How do they propose to find this dominant position? They basically use the Air Tours framework, and for those who don't know, the Air Tours framework is from a judgment in a case called Air Tours, where the commission basically and the court endorsed that use a very economic-based framework for saying basically, is this an industry where there might be tacit collusion? You basically translated economic conditions, sort of few firms and a lot of transparency, sort of thing. So my worry with this, and I think it may actually be something I wrote because we had it in many years ago. We had it in the first discussion paper, and then we took it out. They took it out in the guidance paper because we think it didn't make sense, and now it's back in. And my problem is this is from mergers, right? The Air Tours criterion is where you look at an industry from the outside, and you're sort of saying, oh, is this an industry where a merger, further concentration would make it easy to collude, right? To tacitly collude. But here we're talking about something that abuse of dominant position. So can we just go use the Air Tours criterion, or do we have to, which is sort of like, well, there might be something in the future, right? Or do we have to say do something more, right? In order to say, well, here is we can prove that there is a dominant position. Air Tours is more like forecasting, well, it will be a dominant position in the future. So I'm not really sure it fits. And there's nothing about whether this dominant position somehow should be connected to the abuse, right? So we somehow see that, okay, this group, they are abusing together, for instance. Like some of the very old case law on abuse of collective dominant position was where you saw that they were doing something together. It doesn't say anything about that. So can one firm abuse a collective dominant position on its own? I don't know. Doesn't say anything about this. And the reason I say this is I'm a very old man. So I was also involved back in 2000, I think it was, or early, yeah, back in 2000, when the telecoms regulation system was set up that relied on significant market power, which is basically the same as dominant position. And at the time, there were, and this was basically, I think, an attempt by the commission to sort of narrow a little bit what was going on in regulation. And there were, at the time, national regulatory agencies who were pushing very hard to have something about collective dominance, because that meant that they could impose, if they wanted to use that to impose access conditions on a firm that was not dominant on its own, but was collectively dominant, right? So I'm a little bit, I don't really know where this is going. And I think it's a bit odd also why this has come in, since there's been no cases over 20 years. So why is there suddenly a need to have that? So I don't really know what's going on here. And I don't know how it would look. There are no cases that can say this is the way it's done, but somehow it was still put in. So I think this is a little bit odd, and I'm a little bit worried about. They have something that's they call general principles, and here already we're getting into contentious territory, because it says it's generally necessary to establish whether the conduct departs from competition on the merits and whether the conduct is capable of having exclusionary effects. It's not completely clear to me whether they are saying it's cumulative conditions, but probably they are. Then, of course, there's a whole debate which has gone on for years, and I decided like 10 years ago that I didn't want to waste my life on it, which is what the difference between capable and likely and effects are. But it sort of says we only have to say whether this is competition on the merits or not, and then whether it's capable. But then they say, well, we have some tests that we all know, and there it's already decided that it's liable. And so therefore, for those, it's already not competition on the merits, and it's already capable of having exclusionary effects. And then later on, it's not completely clear to me that this is really done in a consistent, and we'll see that when we get to the specific legal test. According to Marx, this is the guidelines that provide a framework to assess when a conduct departs on competition from the merits. I'm not completely sure of that. So this framework, again, according to Marx, but that is what is in the guideline, draft guidelines also. It says, well, there's something called naked restrictions, and they are always considered off the merits. And naked restrictions were basically already in the draft, in the guidance paper, is basically where the types of behavior where there simply cannot be any good reason other than exclusion, like burning a factory or paying a company for not testing even another company's products or this kind of stuff. And then they're saying, as was just on the other slide, that for abuses with a specific legal test, this thing of on or off the merits is already incorporated in the off the merits is already incorporated in the legal test. And I'll get back to that because I'm not sure it's so clear for even the ones they mention. And for other ones, then, so the, so these where we don't have a clear test, then they basically give a list of elements that are saying, well, the commission or the courts have found in the past that these can be competition, which is not on the merits. And that can be a breach of other laws when it affects competition parameters, deceiving behavior, exclusion of hypothetical as efficient competitors. And then it says something about the AEC test, the as efficient competitor test, used to establish competition off the merits for pricing conduct, stricto sensu, so predation and margin squeeze. And it could, so you have the actual test for predation and you have the established test for margin squeeze. So there it's clear it is the as efficient competitor test that the courts have said that should be used there. Then for the others, they say, well, maybe we could use it there also. We'll get back to the detail. But this is supposedly the framework. But if you look at this 3 here, would you know on the basis of that how to establish whether something else is competition on the merits or off the merits? You have a list, and then you have this AEC test, which you may not be able to use. And this is my problem. So I mean, this is not a framework. It's not clearly defined what it means, right? There's a list of things. Oh, here, this is what we found in the past. May helpful, and if not, you're on your own, right? Basically. So here what they say also, the concept of competition on the merits covers conduct with the scope of normal competition, within the scope of normal competition on the basis of the performance of economic operators, and which in principle relates to a competitive situation in which consumers benefit from lower prices, better quality, and a wider choice of new or improved goods and services. So here it's almost sounds as if competition on the merits is something that benefits consumers. But on the other hand, the Commission, union courts have highlighted that a dominant undertaking's intention to compete on the merits, even if established, is not sufficient to prove the absence of the abuse. Moreover, a dominant undertaking may have to refrain from engaging in certain practices that are unobjectionable for undertakings that do not hold a dominant position. The mere circumstance that the conduct is also implemented by non-dominant undertakings in the market is not sufficient to exclude that it departs from competition on the merits. So the fact that others do it doesn't mean that a dominant firm is allowed to do it, which we know. but it doesn't really help you find out what it means, right? It gives some slides, and it gives a list, which we had on the slide, and the thing is, the top almost sounds as competition on the merits is something that is good for consumers, but that is clearly not what they mean, right, later on. So you have this concept which is given a lot of emphasis, because it sounds like you have to show it, right? You have to show it's not competition on the merits and that it's capable of harming competition, but you're not told what it means, right? So it's not really an analytical help, right? It doesn't explain to you how to do it, in my view, right? And I think, although it is there, and I think that's also what some of them say, well, it's there, we have to do it, right? The courts have sort of said it. But I think there could be other ways. There are other ways to do it. And here it seems like it's giving a lot of weight, like every single time somebody has to establish that, whether if you're outside these traditional, whether it is competition on the merits, and we don't know what it means. So I'm not sure it makes that much sense, and it's been criticized quite a lot. So this is Marx again on what does this capability mean? And first of all, there's a broad meaning of exclusion, reducing actual or potential competitors' ability or incentive to exercise competitive restraint. Be full-fledged exclusion, marginalization, increased barriers to entry, expansion, constraints on competitive growth. It says, well, there's no need to establish that the conduct is the only clause. It could just be helping to produce the exclusionary effects. Counterfactual says, well, we just have to have one plausible scenario and not necessarily pinned down on a very specific one, perhaps. So these first two, if you look at it before we get to the last one, the problem there a little bit, I mean, it doesn't really say, well, what is is there a standard? Do we need to, is it just enough to give a little bit of help? Be one little, one of 100 clauses, even if it's not, there's no, and also there's no de minimis. So again, it's not, I'm sort of a little bit, what is actually the standard? How much is needed to show? It's not really clear to me. And then what is something which apparently is very important to the team is what they call this modulation, and they're very proud of this, in the burden of standard of proof. So they're saying, well, there are some conducts on one where the commission needs to show capability to produce effect. And again, whether it's capability or likelihood, I don't want to discuss that now here, but they like capability. You could have chosen likely because the courts also say likely, but they chose capability. So there's those where they need to show capability. Then there's two conducts with a high potential of exclusion, which are subject to a soft presumption, and three conducts with no interest other than to exclude, the naked restriction. The 1 and 3 here were both in the guidance paper, right? And the 3 is not a very large category. So basically, the guidance paper was saying, well, you should have to show capability. And here, instead, they said, well, a lot of the things you don't have to show capability because it's already, there's already a presumption. And that is really at what I think is at the heart when they talk about workable approach, right? They want to try to push to make it easier for the commission to win, to show and win the cases. So what are these that are? What are these category 2? They are exclusive supply or purchasing agreement, rebates, conditional exclusivity, and that is a big jump. So we'll come back to that. Predatory pricing, margin squeeze, in the presence of negative spreads, and certain forms of tying. And the draft guidelines then say that, so here, exclusionary effects can be presumed, and a dominant undertaking can then seek to rebut this presumption. and then the commission can sort of say, well, your arguments are rubbish, or try to make some analysis itself, right? And even there, then the commission comes in and says, well, even when the commission then has to come back with its own evidentiary elements, demonstrating the capability of the conduct to have exclusionary effects, even that scenario, the evidentiary assessment must give due weight to the probative value of the presumption, reflecting the fact that the conduct at stake has a high potential to produce exclusionary effect. So even when, so the commission starts with a presumption, the dominant firms come back with some evidence, and the commission then puts some evidence to counter that. And then the commissioner says, well, we should still be getting a lot of leeway. We should still, because this presumption should still help us when we are in that discussion. And very interesting, in a document that is filled with references to case law, there is no reference to this in the case law. So how does this work in practice?
Sven, can be like for this last, your last point, like would, for example, like DMA obligations, like be a sufficient reference, like of, like a conduct that mirrors like a prohibited conduct in the DMA, perhaps not by a gatekeepers, but by another company, dominant company. And in that case, I mean, it's not the case law, but it's a regulation that is, of course, targeted to gatekeepers that says that conduct is bad. We presume that the conduct is bad and we prohibit or we ask to comply. So I don't know, maybe true, there is no case law, but there are regulations that are based on, let's say, more or less competition law considerations like this one.
But listen, this comes from Intel paragraph 138 and 139, right? And I think this is a very strange reading of Intel 138 and 139, right? Because I think now we're getting really nerdy, right? So Intel in the ECJ decision on Intel, the court basically goes in and saying, yeah, we know there is a presumption, but as soon as the dominant firm comes with some evidence back to this, then the commission has to analyze this and this and this. And I really read it, and a lot of people read it saying, because it was basically, to some extent, reverting on what has been case law. He was changing the case law. It didn't want to come full out and change the case law with banners. So it says, well, the presumption is still there. We're going to clarify it, I think the wording was. But I mean, it's very odd to then, I think, I mean, I don't understand, then come in and saying, yeah, but in the end, the commission should still win because this is what this says, right? Anna, you are more an expert than me, but...
No, I thought that when you mentioned margin squeeze, that was a very good example for showing this modulation that could be inferred from case law, because you said that when margins are negative, that would be the second category. And I think that both when margins are negative and the input in question is indispensable, then you are in the second category. But if margins are positive but below costs and input is not indispensable, that it can still be found guilty of abusive margin squeeze, but then it would go, I think, to category number one. So maybe the case law is not explicit about that, but probably since this modulation approach maybe was formulated now in such a clear way, it can be inferred from the case law by reading in between the lines. That would be my guess.
But what I mean, what I make this case for is this thing where they're saying, even if we go in and we start debating, so they rebut the presumption they try to rebut the presumption with evidence, right? And the commission has to come back with its own evidence. Then the presumption should still be there to sort of on our side. This is what they're saying. Do you have an explicit reference to that? This is what I mean, right? And then because that is not in Intel, right? Where the court said this out, it's not there. So, and my guess is if they had a reference to it, they would have put in, right? So this is new ground, and I'm saying this a lot because I'm putting because this is really at the heart of what they're trying to do, I think, right? And with the guidelines, right? They really want to say, they want to go back and give more value to presumptions, which of course just somehow makes it life easier. It tilts the balance in favor of the Commission, right? So this is what they mean by the workable approach. Then they say, okay, so that this was about the what are the then Commission when they have to go and look at capability? There's a list here, five things, six things. They were basically in the guidance paper. They are basically also paragraph, 139 of Intel, where the court said once, basically, the court basically went in and then in Intel and said, okay, there's this presumption, but if the parties come back and rebut, then we have to go and discuss these elements, which were almost taken from the guidance paper, right? So this is sort of, to some extent, neutral ground, except that they drop possible evidence of actual foreclosure because they don't like the word actual foreclosure very much. So they drop that. But this is sort of neutral. So what is it? What are this? And then there's a list also what the question does not need to show. It doesn't need to show actual harm. Then there's something which I simply don't understand what they mean by, but so finding that a conduct is capable of restricting competition does not require establishing the profitability of the conduct at issue, and this would amount to having to show that the conduct results in actual exclusionary effects. So the last thing I don't understand, why it would be showing actual exclusionary effects, but they don't like word profitability either, which economists sort of like to sort of say, because they're not just saying, well, so would it be profitable for them to do certain things or something, but not that we have to show it, but it tells us something, but they don't like that either. So that is taken out. They don't have to show.
Wasn't the profitability referring to the prioritization of cases that the Commission would look at and not as a part of the kind of evidence that would have to be considered?
But I think we sort of tend to say one thing is, would a dominant firm, does it have the ability to do something? Often it has the ability to do something. It would just shoot itself in the foot because it would lose money, right? And so often we thought of it, I think also in the guidance paper, there was some thinking, would it have the incentive to do something? Would it be profitable for them to do it, right? Or would they just be shooting themselves? And this, it seems they don't really like, right? So I'm not sure you can find the word profitable otherwise than in saying we don't have to do it, right? Direct consumer harm, which is sort of okay, as long, but it would be nice to have the sort of showing something that it's maybe indirect consumer harm and not just showing harm to competitors, for example, harm to or exclusion. Or so also say we don't have to show that the actual or potential competitors affected by the conduct are as efficient, which also makes sense. They say the conduct is enabled by a dominant position, and that's an old discussion, which I guess have been cleared by the case law, of how do you view abuse. Do you say the abuse is something that the dominant firm can do or only wants to do because it is dominant? And another way of doing it, the other way of looking at it, saying, and then you would say that the abuse is only that. You can only have abuse if there's a direct link to the dominant position that it only is able to or wants to do it because it's dominant. Another way of looking at it is to saying, no, abuse, there can also be abuse simply because even if other firms would also do it, can do it, and would do it, even if they're not dominant, the effect of a dominant firm doing it is much bigger. And then therefore that is also, it's abusive if a dominant firm does something that it's might also, other firms might have done the same thing, even though they're not dominant, right? So these are two different ways of looking at it. And the second one has won. I mean, if you think of AXO, for instance, the AXO-Seneca, right? The behavior that AXO-Seneca was doing, also non-dominant firms could have done that and probably may have found it profitable to do it. So, And we were debating that internally at the time also, okay, and we said, no, and that has won. So this is what they mean by this, is saying basically, well, the second view has won, right? Also things that has a bigger effect because of the dominance, even if others could have done it and would have done it in the same situation, even if they're not dominant, then a dominant, it can still be an abuse of the dominant position if a dominant firm does it. And they also say there's no de minimis, so there's no smallest, so there's no tiny abuses that we don't go. This category 2, I think it's interesting to think about how would this work in practice, right? And I've been involved in discussions inside, of course, about this, right? So not of course, but I have been involved. So the problem is a little bit, it seems to show that because you don't have to show anything, because it also means, first of all, you don't need to have the theory of harm. You don't need to show how things would develop, right? Because all this coverage and so on, that is basically sort of like a theory of harm for why there would be an effect on the market, right? But you don't have to show that, because that is in the list of things on slide 11 I had, where you go in and look at the position of the dominant undertaking, the conditions on the relevant market, the position of competitors. You don't have to do that if you have the presumption, right? So that seems to say that if you just find one exclusive contract, the burden of proof shifts to the dominant undertaking. Now, if you think of it in practice, of course, the dominant firm will come back and come with some evidence, right? At least I've never seen an abuse of dominant case where they didn't come back and threw out the procedure. So they will try to rebut, right? So that we will be dragged into this list here, and you will be dragged into it. So I'm always saying, what is the point of it, right? We will end up discussing in detail what works on the market, and we will be discussing coverage, right? I mean, if you come with just with one contract, if it's with 10% of the market, of course the dominant firm will go, but that doesn't cover, it only covers 10%. What do you mean by this? So we will be dragged in. The commission will be dragged in, you would be dragged in. So relying on this just sort of blind, I mean, I don't think anybody would dream of that in the end. So you will in the end have all this evidence on both sides. So what is it they are saying, the commission? Yeah, and I was trying to speculate, what is it they want to do with this? What's the whole point of this? And the part of it must be, I think, I mean, I'm trying to think what is really the point, is that you want to be able to win a little bit by saying, but these are not very good arguments, or that piece of evidence you have come with is not convincing. That gives the commission a chance of rebutting on technical arguments, saying your econometrics is not good enough, right? And then, since your submission is not good enough, even if it claims that here something about the market and so on, well, there's a problem here, and therefore it's off the table. So that's at least one way, and then we're back in the presumption, right? If you could drag out, if you can rebut the evidence, then you're back on the presumption. So is that what they have in mind? That could be what they have in mind. Or the other is, and that is, of course, to some extent, if you know, efficiency defenses are always thrown out of some technical arguments of no, it's indispensability or something like that, right? So maybe they are trying to change the discussion here and sort of being able to win by just rebutting and never really get to where they have to, where the commission has to show its own hands, right? So maybe that's what's going on. Or the other thing is to saying, well, we're sitting, there's something here, then we win because we still have the presumption. We have the trump card of the presumption, right? So, because as I say, it's not that I can imagine that we would ever only have the presumption and then dominant firms are just going to say, oh, you have a presumption, you win. There's always going to be a discussion about it, about the details. So here it seems that this must be the point, right? You're trying to find a way to win when the evidence is on the table, either by throwing the dominant firm's evidence off the table by saying that they are not good, it's not good enough, it's technical problems, or that it has a high, or that then the presumption wins. So I'm not sure how this is going to work out, right? But surely the final word will be said in Luxembourg. And the thing is, these things are things judges care about and think they know just as much about as commission officials and people in the legal service, right? They may be more nervous about technical economic arguments, but on this kind of thing, who should have the burden of proof of what? They're going to say, wait, this is something we decide, right? This is not something you just invent, right? So this will be very interesting once this gets to, because exactly because I said I couldn't, there's no reference to it in this framework on, and it's not that they can say, oh, we have 16 cases where the court says I couldn't see anything, right? So this will get down and there will be discussions about it. It will be very interesting. And I can imagine there are several lawyers in Brussels who are sitting salivating with the idea that they can go down. Sorry.
Just to throw in another idea, can the presumption also be seen as a way to make the proceedings faster? So you get, thanks to the presumption, you have the company coming in with the rebuttal evidence in an earlier stage of the proceedings. And after that, you can focus, the commission can focus on that evidence instead of first amassing its own huge evidence of showing the capability to exclude, and only then having the company come in with its evidence. So you kind of, the presumption allows you to skip and get to the part where you disagree more faster. Maybe just an idea.
Yeah, I mean, I understand. And that is also what the court sort of somehow says, right? But of course, once you are out of the presumption, then you're just sitting and discussing, right? Then there's evidence on both sides, right? And then what, right? And here they are trying to tilt by this saying, well, we still have the presumption in the pocket, right? Or that the commission. So it's a bit, yeah, we'll see what I mean, because I mean, the way I read what the court said in Intel was basically said, yeah, there are these presumptions that we did 30, 40 years ago. And now we don't really think, we really think we need, and basically this is all about, do we need a theory of harm? Do we need a good story, right? Why are these 1 or 2 or 3 exclusive dealing contracts, are they big enough that they affect the market, that they really make like differences? Somehow explain what's going on the market, right? Basically, the commission is saying that is not our job. We have the presumption, right? We don't need a theory of harm. We have a presumption. So I'm not even sure you can find the word theory of harm in there, right? While the guidance paper was built up, and again, my baby a bit, and I did, was sort of built out, okay, how would exclusive dealing work? What is it we think that could happen in the market? What is it, what was the market going to look like? When do we think it's not that problematic, right? But and it's not really built like this, the guidance paper, because it builds on these presumptions and saying, well, but that's all for the other ones, right? So let's see, but but it will be interesting. There will be, and there are still, I mean, people are, as I said, other people discussing it. So let's go to the specific. How am I doing on time? 15 minutes. Okay, so I have to speed. Exclusive dealing. Now, what they say is exclusivity rebates are now clearly seen as a form of exclusive dealing. Exclusivity rebates are the Intel rebates. Right, so where you basically you give rebates if you promise to buy 90% of your needs from me, right? That does not really. I actually agree with that. I should say it's one of the things I think we got wrong, and a lot of economists don't agree with me. But I actually think that we should do it. Intel should not have been run the way it was run, but there was a way it was run, and the courts basically have gone in and said a lot of things about the insufficient competitor test and the sufficient competitive principles. It's all over the place. And you'll hear from Anna and probably in the next slide, it's in cases where I don't think it even should be it's all over the place. And here they sort of, okay, now we do something. So I sympathize with it. We'll see how it goes. Tying and bundling, there the guidance paper talked about foreclosure. The word foreclosure does not exist in the draft guidelines, not one place. There's nothing. And the guidance paper talked about, well, that could be sort of foreclosure, which is actually okay because it's not really doing anything that harms consumers. Any competitive foreclosure, the word foreclosure is completely gone. And here it talks about significant competitive advantage of DOMCO. So it's not about foreclosing, it's simply getting an advantage in the tied market, which is quite different from what I thought tying was about. Then there's something about, and here, this is where these presumptions really start going. Then they're saying, well, these presumptions we don't really rely on now, not that much when the tied product is free. So we are sort of in Microsoft territory and probably, and it's easy to obtain alternatives to the tied product. Then the presumption doesn't work suddenly. But what? Okay, not clear. And again, I say here it's not clear to me with the cumulative. And it says something about looking at what has actually happened if tying had been in place for the long time, which is sort of said before, we don't really want to know anything about. Refusal to deal. The guidance paper treated margin squeeze as a subcategory of refusal to deal. The courts did agree with that. So obviously the guidance paper, the draft guidance paper followed the court. So there's a separate section of margin squeeze, which is outside of the margin squeeze section. And there's also a separate section of certain access restrictions with the guidance paper head. I know they'll have more on that. There's a slide on that. So again, these are moved out on the refusal to deal category. So the guidance paper basically treated everything of where you're at getting access to the infrastructure or products from a firm, from another firm as a refusal to deal, and therefore that the Bronner criteria of indispensability should be applied. The guidance paper talked about elimination of effective competition on the downstream market. The draft guidelines say part of the requesting undertaking. So it's a one firm we are talking about, not the market here. That's probably what the case law says. I was the one who tried to put in that effective competition. I was saying, okay, if they say no to one, why do we care, right? As long as there's competition on the market, that has now been gone back. I'm not sure it makes that much of a difference, but that is probably what the case law says. And then there's sort of a slightly different wording if you compare the guidance paper, the draft guidelines on IPR issues, and that is probably reflects what's in the Microsoft judgment. So not hugely controversial here. Predation, then economists think of predation as a sacrifice. It means you're not taking what is the optimal price. You're charging a lower price in order to kick out another person, and then you hope to be able to lower the price. So that's a big definition. So that we put in the guidance paper, that's not there now. It only talk about lower prices, below cost pricing. Maybe because sacrifice somehow has to do with profitability. I don't know, but it's a bit odd, right? So the definition of predation, normal would be understand as predation is not there. Now it's just about below cost pricing. They also say rightly that predatory pricing can take place in a market segment or be applied selectively to specific consumers. But again, does it then, which I think is fine, that makes a lot of sense, and I think that's where you find predation. It's not necessarily in the whole market. But does the presumption work here? If it's only one instance of below cost pricing, can we then say that the burden of proof shifts to the dominant firm? Or should I give a story about it? And I thought I had put something else, but something must have gone wrong here. Because also the presumption, does this presumption also work if the prices are between average variable cost and average total cost? Then you have to show something more. You have to find evidence or something. So again, it's not completely clear, this presumption talk. I can see it's clear we have a presumption, price below average variable cost. That's from AXO. That's clear. But the other one, is there a presumption? It's not completely clear to me. And the margin squeeze, here we say it's not necessary that the upstream input is indispensable, which is what the courts have said, contrary one to the guidance paper had argued. And the draft guidelines say the conduct must be capable of producing exclusionary effects. And then this can be presumed if spread between upstream and downstream price is negative, but not if it is positive, but not big enough to cover the coast firms. This is very odd to me, but maybe they have case law, depending on what's case law. So basically the idea is you have the upstream firm and a downstream firm, and the upstream firm charges is active downstream, charges a price to the downstream competitor, and then has its own thing. So if the upstream price is lower that it's charging, the other firm is lower than the downstream firm, then there's a presumption. But not if what I thought was a normal margin squeeze test, which is, does it cover the cost, also the cost of, can the downstream firm competitor operate profitably on the basis of the prices that are going, would it be able to offer it profitably if it had the same cost as a dominant firm? There's no presumption. So apparently, so also a little bit odd to me. So conducts with no specific rebate test, then we have lots of all the ones that are not exclusivity rebates, except if they're marked. So and here we have this problem that they're saying, well, if it's on conditional on market share, but the market share is not very big, then there's no presumption, and it's not treated as exclusive dealing. If it's high, then it's treated as exclusive dealing. And here it may be appropriate to use a price cost test, but not when the emergence of an as efficient competitor would be practically impossible, in which case even a less efficient competitor may also exert a general constraint on the dominant undertaking. And this people always say, and then I've always said, but I could make the same argument for predation, couldn't I? Right. So why is that not also a good argument? But apparently that's not a good argument for predation, because there is a case law on saying that. But of course you could say, if it's saying, well, we want to give room to something that's not yet as efficient, it should take some time. So therefore the dominant firm is not allowed to price down to its own cost, because this other guy has not arrived at those costs less. But as I say, I could make exactly the same argument for predation and margin squeeze, and therefore there should not be the presumption. Only there should also be there should not be an above cost presumption for predation, which normally we say there is. So I'm not sure it's consistent. It may make sense, but it's not consistent. Multi-product rebate, there's very little, and for some reason they say analogy to exclusive dealing and conditional rebates instead of bundling. Multi-product rebate is when you're selling two different products, and you gave a rebate, so it's cheaper if you buy them together, right? But to me, that sounds more like bundling than it sounds like exclusive dealing. So I don't really understand that. It's not that much. And then there's self-preferencing, which was not in the guidance paper, which came out with the Google case law. That is a dominant firm giving itself preferential treatment to its own products compared to those of competitors. Again, here, it's not about foreclosure, it's about gaining an advantage. And there are some elements here, which basically all come from Google and probably have been a little quickly. I read the Google judgment as probably reflected in the Google judgment, so it may have to be fine-tuned a bit. I'm still not sure I've understood. There was a famous article about refusal to deal or that was not the word, by Philip Arida, where he talked what are the limiting principles, right? And said this is very similar. I'm not sure I've understood what the limiting principles of self-preferences is, right? Is it self-preference is if a dominant supermarket puts its own products higher up than maybe, I don't know, we'll see. Access restrictions, these are the ones that again were in the refuse to deal or refuse to supply in the guidance paper, and now they've moved out. So this is basically, it means they're indispensable. It really is not necessary. says dominant company examples, dominant commercial practices may lead to disruption. So it's if you're already supplying, then you can't stop like that. You don't have, or at least you don't, you can't say that it has to be indispensable. They have to show its indispensability. If the regulatory obligation, that was already more or less in the guidance paper. If it downgrades or delays existing supply, and if it's said it would be shared. So basically all this means that the Bronner criteria only should be applied if you really never have giving any hints that you were going to share them, right? So if you do anything, if you already sold, and or if you said you were going to share, then you cannot later on say that the other parties have to show indispensability, then you're out, then it becomes a more general, easier criterion. Then just very quickly, objective, there's nothing particular. I think it reflects the case law, the law development, which actually took up the, which introduced Article 102 efficiency defense, and the courts took that up on board. So that is there. What is interesting perhaps is sort of try to have a look and saying, look at the, there was in the guidance paper, there was a section on efficiencies in every section that's gone completely. And again, I thought I'd put something more in, apparently I hadn't. I had also written it's sort of interesting to think about what is the standard of proving efficiencies compared to the standard of proving the abuse that now has been lowered a lot, but still very high, it seems, burden for showing. So it's not really. Then I was going to think, I had a slide, I don't know what I've done. I had a slide, if you want to write down, there are 4 people I would, people who think a bit like me, who have written something. One is Asimakis Komninos, who has written in a network law review, and I have them here, I think. Yeah. So Asemikas is a lawyer who has a lot of experience has a PhD from European University Institute, and has a lot of experience in Article 102 cases. And he was, for instance, Google's lawyer in the case that just going. And he has written something, starts with j'accuse, and then there is Luc Peperkorn, who is who worked on the guidance paper, who I worked with, and who is sort of the grand old man, and who has been very active in the debate and defending. He's the big defender of the guidance paper. So he has also written a comment in some Kluver law blog, I think it is. Damien Nevin, who was a chief economist at the time of the guidance paper, has also written something. And finally, Jorge Padilla is coming out in Concurrence, and they sort of have various aspects. They're all critical in one way or the other. I don't agree with all of them, but they are sort of they're big names. And Jorge Padilla is the, I guess, the top economic consultant in Europe, who has written a book also on Article 82, together with a barrister, UK barrister, and he's also coming in the debate. So there will be more. So it's a very interesting thing to follow, and quite fundamental. If other people criticize in the way these people are doing now, then it's not necessarily going to be easy for the Commission to find a way to get this or maybe they will maybe they don't care. Maybe you will all go and applaud them, because it also is, of course, an attempt to make your life easier. But it's going to be a very interesting debate over the autumn now. Thank you.